Hi folks, it's Kid Malek from Malek and Malek. Today, in this vid, I'm going to talk about the various forms of compensation which you may be entitled to through your allowed workers' compensation claim. So, the first and the most basic form of compensation which you may be entitled to is called temporary total disability compensation, otherwise known as TTD comp. It's shortened that way. This is the most basic form of comp. You're entitled to this comp, or you may be entitled to this comp if you are unable to work due to your work injury, the conditions in your work injury, or you've been released back to work with work restrictions and your employer has not given you a light duty written job offer that accommodates those work restrictions. So those are the two bases under which you may receive temporary total disability comp. It's paid for the first 12 weeks of comp. It's paid at 72% of your full weekly wage, or FWW, and then if you're off work beyond 12 weeks, then it's paid at 66 2/3 of your average weekly wage. I've done other videos where I explain what the FWW is and the AWW is and why you want to get those wage rates as high as you can. So I'd ask you to watch those videos to learn more about that stuff. So it's temporary total disability. I mean, by its very nature, it's temporary. It doesn't go on forever. So at some point, you'll be found to have reached maximum medical improvement for the conditions. So it doesn't mean you're better. It doesn't mean you're back to normal. It just means within the rules of the workers' compensation scheme, it just means that treatment, surgery, etc. has been thrown at those conditions, and they've reached like basically what they say is a treatment plateau, where it's not contemplated that the condition will either get worse or get better. So at that point, your comp will be terminated. And then, because it's no longer temporary and totally disabling, it's either permanent or it's gotten better or whatever. But that's when TTD cuts off. That can be, let's say your TTD has been cut off, your temporary total disability comp has been cut off. There's ways to renew the entitlement to temporary total disability comp. It's called, if there's new and changed circumstances within your claim, that can renew your entitlement to temporary total disability comp. So those new and changed circumstances may be things like you've got another condition added to your claim. That new condition, there's been treatment authorized at that new condition, and like you have, let's say you have a shoulder sprain, your shoulder sprain's been found to have reached MMI, but you subsequently end up having a rotator cuff added to your claim, and then looks like there's going to be surgery at the rotator cuff, then that would be new and changed circumstances. So that's basically that's one simple way. Another way, you go back to work and then you have an exacerbation of the pain and discomfort due to your allowed conditions. That may be another way to get temporary total disability comp. A caveat: you cannot work and receive temporary total disability comp at the same time. If you work and you receive temporary total disability comp, I've talked about this in other videos as well. At best, that's an overpayment. At worst, it's an overpayment and criminal fraud. So don't work and get temporary total disability. So that's TTD in a short little segment. Another basic form of compensation is called permanent partial disability award, or also they call it PPD or a C92 award, because the way you apply for it is within a C92 application, and you're entitled to file for a C92 or a PPD award 26 weeks after the date of injury, or 26 weeks after the last receipt of comp through your claim, whichever is later. So what will happen is you'll file it, you'll undergo an examination by an IME, independent medical examiner. That examiner will assign you a percentage for the permanent partial impairment for the allowed conditions, and then for each percentage that you are assigned for the allowed conditions, you'll get 2 weeks of comp and it's paid at the PPD rate. So the PPD rate, it may be pretty close to what if your AWW is not too high, it actually might be, they might align, or it could be if you have a really high AWW, average weekly wage, then it's capped. Essentially, they're not the same. You're not going to get the AWWs for the temporary total disability is not the same AWW for PPD. Each year they're capped at a certain rate. So again, for every percentage, you get 2 weeks comp that's paid out in a lump sum. It's not a settlement of your claim. That's like a common misconception. At least once or twice a week, we'll get a communication from a client that says, "Oh, they said they're, I'm getting this PPD, my claim's done, or does this means I'm settling?" No, it doesn't. Just a C92. It's just a compensation that you're entitled to for your work injury for the conditions allowed in your claim. In addition, you can file for increase in your PPD award. So what you can do is, if your condition gets worse, you have more treatment after the initial assignment of PPD, you can file for it. If you have additional conditions, you could file PPD increase for those conditions. For a PPD increase, if it's already like conditions that already been allowed in the claim, you'll need to get an exam before you file the PPD increase. So for the initial application, you do not. For the PPD increase, you do. So that's TTD and PPD comp. The next form of compensation, they're kind of similar. Working wage loss and non-working wage loss. So we'll start with working wage loss first. So what will happen is, let's say you go back to work either at your current job or you find another job, and at that new job, because of the allowed conditions in your claim, you suffer, like you make less money, either because you're being paid less or because you're working less hours. So what will happen is you'll be compensated. The difference between your AWW in the claim and the money that you're earning now, you'll get that difference. It'll be paid 6 2/3 of that difference. So let's say you're working 40 hours a week and you're in the past and your AWW was 100, and now you're working 38 hours a week and you're making $70 a week. So you would get 30 times the 6 2/3. 100 minus 70, 30, and then you do 6 2/3 of 30, and that's your wage loss. So again, everything with workers' comp, it's never a one-for-one. It's never a one-for-one wage replacement, and it's the same thing with working wage loss. So it's not 100% compensate you for what you used to make, but it's to make it up a little bit, or it's supposed to make it up. What you have to do is you have to have work restrictions. So if you're released to work completely and you're working a new job or a current job and you're making less money for whatever reason, you can't file for working wage loss. You have to have work restrictions, and the wage loss has to be aligned. It has to be related to your work related injury conditions. Okay. And then you have to register with the Ohio Department of Jobs and Family Services, and then for each week of wage loss, you have to submit, I think, like 15 to 20 job applications, good faith job applications. So you have to apply to different jobs each week, send those in for each week of wage loss. It's kind of onerous. I think if you work in a new job or different job and you have work restrictions of an hourly nature, so let's say you worked, you have 30-hour work restrictions by your doctor, and you're receiving 30 hours of work at your new job. I believe in that situation with that time restriction that you're not required to file the job application searches, but otherwise you do. So it's kind of a pain in the butt, but it is what it is. And the thing is, you could get this kind of. Well, let me go with the non-working wage loss, and then I'll go talk about how long you could get these forms of comp. So non-working wage loss, it's essentially you're going to be filling out the same forms. Your doctor is going to fill out the same forms. And what happens is you've been found, you may have been, received temporary total, and then you've been found MMI, but you can't get a job yet. You haven't been able to find a job. So you can file for non-working wage loss. Non-working wage loss, you have to have work restrictions. You have to register with the Ohio Department of Jobs and Family Services, and then each week you have to again submit those job applications. And then each week you do that, you'll get the working wage loss. It's essentially, I think it's you're paid at the same rate you're paid at temporary total disability comp. So in a sense, it's kind of like temporary total disability with the extra added requirement that you have to fill out these job search things each week. So that's non-working wage loss. So there's working wage loss, non-working wage loss, and then the living maintenance kind of fits in there as well. Living maintenance is what you receive when you are participating in vocational rehabilitation. So vocational rehabilitation, you submit something, you or your attorney or your doctor refers you to participate in workers or vocational rehabilitation. If you are found to be eligible and feasible, again, with all these things, you have to have at least you have to have work restrictions. If you're completely off work, then you can't participate in vocational rehabilitation. So you have to be able to work, but you can't be released to full duty work. So you have to have work restrictions. And again, you have to be found eligible and feasible. So if you're eligible to participate, but you're not feasible, i.e., there's a major educational barrier to your participation, there's a major barrier due to your work injury, then you may not be found feasible, in which case you can't participate in vocational rehabilitation. But if you are, during the duration of the vocational rehabilitation program, you receive living maintenance, and I believe that's 6/6 and 2/3 of your average weekly wage, but it's no less than 50% of what they call the statewide average weekly wage. So for some folks whose average weekly wage is pretty low, you could actually do much better with living maintenance. So let's say for whatever reason your average weekly wage, the comp that you're paid each week is like $100, which would be horrible. But let's say that was it, and you had been receiving temporary total disability at a wage rate of 100. You would get each of those weeks you get $66, which is terrible. But with the living maintenance, it's capped at 50%, not less than 50% of the statewide average weekly wage. You can find all these statewide average weekly wage numbers for each year of the injury. It's a link. I could put it in the notes, but you'll find it there, and it'll be between 400 or 500, depending on what year it is, 300 to 400 to 500, depending on the year of your injury. So now going back to, and you'll get that while you're participating in vocational rehabilitation. So going back to how long you could do non-working, working, and living maintenance. So working wage loss, you could do a maximum of 200 weeks. If you were to do non-working wage loss, you get a maximum of 52. But if you do working and non-working, you don't get 200 plus 52. You could get 200 of working and then a maximum of 26 in that instance. So it's capped at 226 weeks in total, 226. And then if you get living maintenance, again, it's going to eat into the amount of, you're not going to be able to go to 226. So if you do living maintenance, vocational rehabilitation, and then you do working, non-working wage loss and working wage loss, however you add those up, it can't be more than 226. Okay. So if you do 52 weeks of living maintenance, and then you're going to have to figure out how much working and then non-working, but it can't be more than 26. So that's non-working, working, wage loss, and then living maintenance compensation. So then the next form of compensation would be the scheduled loss award. So, this is for scheduled loss for either your limb has been amputated completely or your limb has been injured in such a way so that for all intents and purposes it's non-functional. And in that instance, there's enumerated, it's called a scheduled loss because every body part you get an amount of comp for each of those body parts. You get a number of weeks. So like, let's say, like if your hand were to get cut off, God forbid. I don't know what it is off the top of my head, but let's say it's 100 weeks. So you get 100 weeks of comp. Again, I believe that's paid. I'll have to look at my notes exactly. It might be paid at the 6/6 and 2/3 of your AWW, but you'll get that. You get that in addition to your other forms of comp. The other thing is, I think you can't get a PPD and a PPD award and a schedule loss for the same body part. So if you get a schedule loss, you don't get a PPD. So that's the schedule loss for body parts. So if you lose a limb or the limb becomes non-functional due to your work injury, that's another form of comp you're entitled to. I mean, it's hard. I don't know. It's kind of weird to think these body parts have different values and monetary values. It's kind of strange, honestly, but they do with the workers' comp system. So along those same lines of money for body parts and whatnot, you can file for a facial disfigurement award. So this would be a disfigurement that is work prohibitive, or it'll make it difficult to retain or procure employment due to the facial disfigurement. Maybe you got a cut, and I don't know. I guess you look like a pirate, or your face is so burned that it's people will have these biases and be less inclined to hire you for whatever reason. I would think in this day and age we don't have these biases and discrimination, but I think the reality is probably it exists. So because of that, the BWC recognizes that this may be an impediment to getting work, so they're going to compensate you, and it's up to the Industrial Commission hearing officer. Or the BWC, basically they can compensate you up to $10,000. So it's kind of up to their discretion how bad it is. And so probably what you'd have to do when you file for that is you'd file pictures and stuff. So that's schedule loss, disfigurement, and then the next thing is the VSSR award, which for a violation of a specific safety requirement. So if you work, let's say, in some kind of factory setting, some kind of manufacturing setting, and you operate a machine like a press, or there's a saw blade, a cutting thing, and like say a guard has been removed, and you end up cutting your hand or your finger off or something of this nature. However, because of that injury, there's a whole list of things that employers are supposed to, safety regulations that they're supposed to adhere to, and these are enumerated within the revised code. So for instance, and the purpose of the VSSR award is to punish employers for violating these safety hazards that Ohio has recognized as being significant enough that they're going to document what you have to do to avoid getting injured in that way. So for instance, like if you're working on a roof, your employer is supposed to have various fall protection. You're supposed to have harnesses and stuff so that if you start falling, you'll get caught. If there's scaffolding, it has to be in such a way so that you don't fall off the scaffolding and the scaffolding doesn't collapse. So if you get injured in that way, and then there may be a VSSR. Now what will happen is you'll file a VSSR application. There'll be a whole investigation. You'll have a VSSR hearing, and then the Industrial Commission, the hearing officer, will assess a penalty from between 15. If they find that there's a VSSR violation, they'll assess a penalty between 15 and 50%. And what that means is, let's say, and the way you'll be paid is for all past and future comp, in addition to the past and future comp which you have received and may receive in the future. So for all the past, let's say you have 26 weeks of temporary total that you've received. So what you'll do is you'll in addition to what you'd already gotten, if there's a VSSR violation, then you'll get, let's say it's 50%, you'll get 50% of the maximum the maximum amount of comp you could get comp rate for that year. So let's say your AWW is like $400, but the maximum rate is capped at $900. So there's some people, they might make $1,500 So they would only be able to get like 900. But in your case, your wage rate is 400. So what will happen is you've already gotten your 26 weeks of comp paid at whatever your wage rate is. You also get 50% of that for each week of comp. So for 26 weeks, you do 26 times 900 times 50%, and you get that in addition to the comp you've already received. So, and then if you continue getting comp for each week, you'll get the comp plus the VSSR comp. And that is assessed against the employer. It's kind of a punitive thing. It's meant to punish them. It's meant to get them in line. It's meant to serve as a message to other employers. Hey, don't do this. If you're working on roofs, make sure everybody has fall protection. If you're working in a factory with saw blades or whatever, make sure there's guards on the machines. We don't want these injuries to happen. We recognize these injuries to be a problem in Ohio, and we want to avoid them. So therefore, it's kind of a penalty thing against the employer. So that's a VSSR award. Again, the statute used to allow you to file these 2 years after the date of injury. It's changed, I believe, September 15th. So if your injury happens September 15th, 2020 or beyond, you will have to have filed it within a year of the date of injury. So if your injury happened October 1st, 2020, you would better file it before, I don't know, I would file it like September 15th, 2021. So that's a VSSR award. And then the final one that I'm going to talk about is permanent total disability compensation. So permanent total disability compensation is a form of compensation that you may be entitled to if you are found to be permanently and totally disabled. So there's two ways you could be found to be permanent and totally disabled. You could have like statutory permanent total disability. So and there's like listed a combination of body parts such that if those combination of body parts exist in your claim and they're recognized in your claim, then you're statutorily recognized as permanently and totally disabled. Therefore, you would receive permanent total disability for the rest of your life if you wished. And like, for instance, you lose a leg and an arm, or both legs or both arms, there's various combinations. So that's statutory PTE, and obviously if you're paralyzed, that'd be statutory PTE. The other way is, you're found permanently totally disabled by the Industrial Commission. So what happens is, you've gone through the TTD, you participate in vocational rehabilitation, or you've tried to go back to work, that's failed because of your work injury. You file this application, you get examined by various folks. You might get examined by a vocational expert, and these doctors say, yeah, this person's permanently totally disabled because X, Y, and Z factors. And it may be based purely on medical reasons. It might be a combination of medical reasons and the difficulties idiosyncratic to you. For instance, you never learn to read, or you have the education level of a middle schooler or whatever, or you've worked heavy, hard labor all your life. Now all you can do would be sedentary labor, and you've never worked in an office setting or with a computer or anything for your entire life, and you're 65 years old. So you may be found PTD. If you're found PTD, again, you'll receive compensation for the rest of your life, permanent total disability compensation. The nice thing about that is you don't have to have your doctor submit like the Medco 14s every month to certify you PTD. You're just found PTD. And then what will happen is you can file to supplement your PTD. You can file something called dwarf, and it basically it's like to make up for inflation. So, so the deal is, if you're statutorily PTD, the amputation situation, you can go back to work in some capacity. If you are found PTD by the Industrial Commission, the typical way, then you are not allowed to go back to work at all. So it's you're not allowed to return, because the whole point of PTD is he's basically saying, hey, you can't get any gainful remunerative employment. So If you want to go back to work, your better bet would be to either settle your PTD. That might be one thing you could do. What you don't want to ever do is be collecting PTD and then work on the side or work under the table or whatever. You'll be found out. I mean, I think the BWC spends excessive amount of time investigating people. But that's, and they'll find people. You see it all the time. This person was found PTD and they're running a landscaping company and whatever. And one of their statements might be, well, I wasn't working and I wasn't doing well, you're still working basically. So, there's some things you could have rental property and these sorts of things, but you can't be working. Okay. So you can't work, don't work. I don't even think you can volunteer. I think there's even case law that says you're not allowed to volunteer. So, and which, with Social Security disability, I think you could work within up to a certain threshold. But PTD, you 100% cannot. And the other thing is the standard to get Social Security disability and the standard to get permanent total disability is not the same. So there's people that might be receiving Social Security disability may not be entitled to PTD compensation. There's a lot of little caveats and things that you have to that have to exist to get PTD, which don't, the two completely different areas of law. SSD, that's federal, PTD, that's within the Ohio Workers' Comp section. And the other thing is, if you're getting Social Security disability or Social Security retirement or whatever, that will offset, I guess it would be Social Security disability, it would offset your PTD, so you don't get to double dip. But curiously enough, if you're receiving PERS or STRS, the state teachers employment retirement or public employee retirement of Ohio, you can receive both. So you get PERS, STRS, and PTD. But otherwise, you don't get both things. So in short, those are the forms of comp which you may be entitled to through your workers' comp claim. I'm going to put basically a little within the notes section, basically a little snippet of what each thing is, and then you can read it there. Otherwise, if you have any questions, concerns about anything, give us a call, Malek and Malek, and then or leave a comment or email me. And if you get injured and you need help, you could always, we'd always love you to give us a call and we can give you advice. You don't have to sign up with us. It's a free consultation. But my suggestion is, if your claim is complicated enough, that you should hire an attorney. So if you don't hire us, hire somebody in Ohio. Again, there's a lot of really great plaintiffs, workers' comp firms that represent injured workers in Ohio. So if you don't come to our firm, go to somewhere else. But definitely get represented. You'll benefit significantly by doing that. Beyond that, I hope that you stay safe and healthy, and thank you for watching this.